Good afternoon. I just watched this video from California Guardian, U.S. Post Office Ray Charles First Amendment audit, and I'm kind of I just can't understand why this is still going on. Why the levels? I mean, you'll have to tell me if it's incompetence or if is some other motivation for this that I just don't understand. But everything they do in this video is just, it serves no useful purpose. They go into the post office, they make a scene, they assert their right to film, they leave, they re-enter, they are told to leave again, they leave before the cops get there, and then they laugh because, oh, this guy's calling the cops or something like that. Well, what this is in kind of legal terms is they were trespassed and then they left before it turned into criminal trespass. If they truly believed that they had a constitutionally protected right to film inside that post office, you tell me, why didn't they stay? Why didn't they push it? If they had a right to do it, why did they leave? Why did they buckle? They buckled like seatbelts because you can see right here, he's not in there. 6-minute video. They go in, they make a scene, they leave. Smiling, fun and games. I don't get it. It's dumb. Well, anyway, High Desert Community Watch, who I enjoy watching his videos when he's outside and not saying stupid things, is in here, and he brings up, once again, the DHS memo. The DHS memo absolutely does not apply to the post office. It absolutely does not apply to filming the interiors of federal buildings, let alone the post office. How do we know this? Well, first of all, it says that this information bulletin is intended to raise the awareness of FPS personnel, management protective security officers, of the public's right to photograph the exterior of federal facilities. Exterior. Guidance for FPS law enforcement officers encountering individuals taking photographs of the exterior of federal buildings. Doesn't deal with the interior. Guidance for PSOs encountering individuals taking photographs of the exterior of federal buildings. It doesn't apply to the interior of federal buildings, let alone the exterior. How do we know this? Because it references Title 41. Title 41 of the CFR. Let's just do it. 41. Oops, 41 CFR. There we go. Boom. Cha-cha-cha. 41 CFR. What do we got here? What is a 41 CFR? Title 41 deals with public contracts with property management. C 102, real property, general, GSA, Government Services Administration. This deals with the Government Services Administration. 39 deals with the post office. 39 CFR is the post office. 41 deals with, well, at least C 102C deals with the GSA. I think they also deal with some military ones in here. Yeah, Environmental Protection Agency, GSA. Doesn't deal with the post office. So this has nothing to do with the post office. Next we hear, I know I heard California Guardian talking about it. Oh, I'm media. I get to film in here. Have you read Poster 7? You don't understand Poster 7. Well, he makes it very apparent he doesn't understand Poster 7. Poster 7 does not deal with media. You will notice the word media is not in there. You don't have to be media. You just have to be photographing for news, advertising, or commercial purposes. But it says photographs for news purposes may be taken in entrances, lobbies, foyers, corridors, or auditoriums when used for public meetings. This applies. I have not seen this not apply. So it's when used for public meetings. And then we have this except here. What does except mean? It means you could do the preceding stuff except where prohibited by official signs or security force personnel or other authorized personnel or a federal court order or rule. So if the security guards tell you to suck it up, buttercup, and get out of there, stop filming, you got to stop filming. If other authorized personnel tell you to stop filming, you got to stop filming. And that's if it's for news purposes. Other photographs, which would be advertising, commercial, presumably it'd be personal use stuff, may be taken only with the permission of the local postmaster or installation head. So this says that if security force personnel tell you stop filming, you got to stop filming. Otherwise, if it's not for news purposes, you need permission of the local postmaster or installation head. Now you say, well, maybe you're misunderstanding that. Maybe it's only if you're filming in an auditorium, only when that auditorium is used for public meetings, except where that auditorium prohibits it from official signs. Well, you'd be wrong there too. This is 39 CFR 232.1, conduct on postal property. That's what that poster 7 is based off of. Says it in there somewhere, but I don't care to look for it. Soliciting, electioneering, collecting debts, vending, and advertising. We're going to scroll down. Section 5, except as part of postal activities or activities associated with those permitted under paragraph H4 of this section. No stuff can do anything in other exterior spaces. Then we have photographs for news, advertising, or commercial purposes, except as prohibited by official signs. So everything is except as prohibited by official signs or directions of the security force personnel or other authorized personnel or a federal court order. Then we have photographs for news purposes may be taken in those things when used for public meetings. It's pretty clear. It's pretty freaking clear. Then we have U.S. v. Kokinda, United States Supreme Court, 1990. They were soliciting contributions, selling books and subscriptions to the organization's newspaper, and distributing literature on a variety of political issues. Political speech, First Amendment protected activity. They were doing it on the sidewalk that was leading from the parking lot to the post office building. And lies entirely on government or on Postal Service property. It's not one of the Grace sidewalks from the US v. Grace where it goes along the street and people can't tell that it's post office property. This is literally from the parking lot of the post office to the front door of the post office. So they're outside on a sidewalk that's on postal property. District Court affirmed the convictions. They said, yep, you can't do that. The Court of Appeals reversed. Oh, sidewalk is a public forum. And they analyzed it as a time, place, and manner restriction. And then the Supreme Court reversed that. They said no. Why did they say no? Well, first thing you have is the respondents were tried for 39 CFR 232H1, 232.1 H, that's the section we're in, and 1. We're in section 5, but it's still free speech. It's still a First Amendment protected activity. Respondents appealed their conviction, asserting the application of that violated the First Amendment. So they say solicitation is a form of free speech protected by the First Amendment. So there you go. It's First Amendment, all right? First Amendment protected activity. Oh, ho, ho. So then under their First Amendment jurisprudence, they must determine the level of scrutiny. That's what I've always been saying. What kind of scrutiny? But then here we go. The government's ownership of property does not automatically open that property to the public. It's a long settled principle that governmental actions are subject to a lower level of First Amendment scrutiny when the governmental function operating it is not the power to regulate or license as lawmaker, but rather as proprietor to manage its internal operations. Here we have no open spaces, no meeting hall, park, street corner, or other public thoroughfare. Instead, the city engaged in commerce, blah, blah, blah. So long story short, I won't read it. There will be a link in the description. But the government, the post office can regulate what happens on its property. It can preserve its property for the business that it's dedicated to. The post office is there to sell people stamps, to send letters, maybe do passport photos and things like that. It's not there for First Amendment activities. First Amendment activity would be filming. The government can regulate it. The post office can regulate it. They're wrong or they're lying to you. I don't know which. You tell me about the application of the DHS memo. And it's also this Title 41 doesn't apply to the post office. They're wrong in their interpretation of Poster 7. The underlying CFR for Poster 7 puts it backs up that they are wrong about it. And then Kokinda also takes away any legs that their First Amendment claim of free speech has. So you tell me, are they stupid? Are they lying to you? You tell me. Have a great day.